next podcast on CAROTAR 2020, Practical Challenges and Way Forward. CAROTAR 2020 rules were implemented from September 21, 2020. They mainly deal with importers who are importing goods at concessional rate from particular countries. So giving a brief background of how these rules were introduced and the timelines related thereto. On March 27, 2020, that is in Budget 2020, the government introduced the legal provisions in the Customs Act relating to CAROTAR. The idea of the government was that the importer should also have details or evidence that the goods on which he is claiming the concessional rate have actually been produced in the country wherein the country of origin certificate has been provided. Subsequently, in August 21, 2020, the CAROTAR rules were notified. The industry was given 1 month to prepare for these rules and to collate data which is required in these rules. Recently, in October 2020, some FAQs have also been released by CPIC, which have been discussed by us in the subsequent slides. So, giving you a background of how these rules operate. Firstly, an importer desiring of importing goods at concessional rate approaches the exporter. The exporter obtains a country of origin certificate from the issuing authority located outside. He provides this country of origin certificate along with the import of goods to import. Till now, this country of origin certificate was the only thing that the importer required to clear the goods at concession rate. However, going forward, the importer should have prior possession of information that the goods have actually been produced in the exporting country. Only when he has this information can he claim the benefit of concession rate. A part of this information has also to be filed along with the bill of entry. A part of this information has to be retained by him to be provided as and when the proper officer demands the same. However, unless and until the importer has this information, evidencing that the goods have been produced in the exporting country, he cannot claim the benefits of concession. Now, let us discuss what clarifications have been issued by CPIC in the FAQs that they have issued. Firstly, they have clarified that Form 1 need not be provided by the importer at the time of import. These are to be submitted as and when sought by the customer. Notably, the rules mandate that Form 1 should be available and ready with the importer at the time of import. Further, the rules only provide 15 days to the importer to submit this Form 1 to the customs officer when demanded by him. Therefore, it is suggested that at the time of import only, the importer should have Form 1 ready with him. The next clarification is that the importer need not have or seek the proprietary production process from the exporter. He can only seek the description of major components like material, labor, profit, etc. The next clarification is that the production process which the importer has to maintain and seek from the exporter should include the details and manner of fulfillment of originating norms. So, for example, if the importer is seeking detail, he should have sufficient evidence and detail of the production process of how the HS codes are changing, let us say as required at secretariat level. The processes do not simply involve assembling or processing, which have been part under the originating rules, etc. Next, the FAQs clarify that the supporting documents may include an email communication from the vendor, giving the cost breakup, photographs of the production site, and such similar details to evidence that the originating norms have been satisfied. Several other FAQs have also been issued to clarify the doubts of the importer community. Let us now discuss that in the past 1 month, what difficulties have importer faced in importing goods under these CAROTAR rules at concession. The first and the foremost difficulty they have faced is that the foreign exporters have shown reluctance in sharing information, especially when the exporters are unrelated parties. They have raised concerns that the proprietary information related to imported products will be exposed to both the importers and to the government. The confidentiality of this information would come at stake. So with these concerns, the exporters are not ready in sharing the information with importers. Secondly, from the department side, the CAROTAR 2020 coincided with implementation of faceless assessment. So under faceless assessment, the importers are facing a lot of communication gap with the custom authorities to explain their case or to understand the requirement of the department of what exactly is being sought by the department. So, due to this communication gap, the officers are not readily accepting the data submitted by the importers, and they don't even have an in-person opportunity to explain of how exactly the information is these tests of the originating rules are made. So taking an example from the last slide, supposedly the exporter does not provide the profit margin to importer. In such a case, the rules would still be satisfied if the originating criteria details are available. However, because of lack of personal communication or in-person communication between the importer and the custom officer, it is very difficult to explain and convince the custom officer that these criteria have been met and the import should be allowed under the concessional rate. So what is the way forward for importers in this case? Firstly, they should intimate the foreign vendors regarding CAROTAR and the requirement thereof, clearly stating that this is a legal requirement which is not optional, and the foreign vendors have to provide this detail for importers to claim concession. Secondly, the importer should ensure that proper and adequate documentation is maintained, which is in compliance with CAROTAR, so that subsequently, if any information is sought by custom officials, that can easily be provided. Next, at least for new products, the importer should align with the vendors to provide details upfront only, so that subsequently there is no exchange of information and no information is pending from the exporter's side. Lastly, and as a suggestion, the importers may even consider keeping an indemnity clause stating that if the information provided by exporters is inadequate or is false, and subsequently the importers have to deposit some duty, they can seek the same from exporters commercially. Hope you find this video useful. Thank you.